Hi everyone, welcome back to my channel. And today we are going to discuss about collective bargaining with respect to trade union. So definition. The phrase collective bargaining has been coined by Sidney and Beatrice Webb in their work History of Trade Union. The Encyclopedia Britannica defines collective bargaining as negotiation between an employer, a group of employers, and a group of work people to reach agreement on working conditions. If negotiations are between an employer and a group of his work people, the dependence of the work people on the employer for their job weakens their bargaining power, and their collective bargaining is more usually understood to be a negotiation between one or more trade unions and an employer or group of association of employers. Trade union organization gives the work people greater strength to providing means for the expert presentation of demands by skilled officials not dependent on the employees for their job. Further, a trade union has fund and means of obtaining information outside any one undertaking and can secure for the work people at any one firm the support of their fellows in other firm. Now, the Encyclopedia of Social Science considers collective bargaining as a process of discussion and negotiation between two parties, one or both of whom is a group of persons acting in concert. The resulting bargain is an understanding as to the terms or conditions under which continuing service is to be performed. More specifically, it is the procedure by which an employer or employers and a group of employees agree upon the condition of employment applying to all the employees in common. The institution is both a device used by wage workers to safeguard their interests and an instrument to industrial organization. In Black's dictionary, collective bargaining is defined as negotiation between an employer and organized employees as distinguished from individuals for the purpose of determining by joint agreement the conditions of employment. Now, according to Ludwig Teller, the collective bargaining is an agreement between a single employer or an association of employees on the one hand and a labor union on the other, which regulates the terms and conditions of the employment. And we have definition by Buckey and Kerr, then the illustrations on the World Encyclopedia, and we have S.N. Misra definition, and we have many more definition. Now, the principle of collective bargain has been adopted by International Labour Conference ILO in 1951, and here the first is machinery appropriate to the condition existing in each industry should be established by means of agreements or laws or regulations as may be appropriate under national conditions to negotiate, conclude, revise and review collective agreements or to be available to assist the parties in the negotiation, conclusion, revision and renewal of collective agreements. And the second statement here is that was adopted by ILO is the organization, methods of operation and function of such machinery should be determined by agreements between the parties or by national laws or regulations as may be appropriate under national condition. So this is the principle of collective bargaining that was adopted by ILO, that is Industrial Labour Conference, ILO in the Industrial Labour Conference in 1951. Now, the object of collective bargaining. The object of collective bargaining is to harmonize labor relations, promote industrial peace by creating equality of bargaining power between the labor and the capital. The object of collective bargaining is to satisfy both employees and employers by way of adjustment and compromise by following the principles of give and take and by bringing the parties together. It is an effective method for solving the conflicts between employer and employees by giving clear understanding between them. Collective bargaining is the best negotiation technique to settle any conditions of service like wages, hours of work, leave, gratuity, bonus, allowances and other like privilege of workers. Now we have some limitations of collective bargaining, and the first is freedom of the individual workman to contract, and the second, statutory provisions under the labor law determined the terms and conditions of the employment of workers. So these are the main two limitations of collective bargaining. Now, freedom of individual workman to contract. Collective bargaining does not suit to labor contracts which are made by individual workers and management, but it results into general agreements between the employer and the representatives of workers about the terms and conditions of employment. A worker whose term and conditions of the employment are determined by his representative in the process of collective bargaining does not prevent a worker from raising his personal grievance. Thus, the scope of collective bargaining gets limited when the right of individual workman to raise his individual grievance is considered. And the second limitation is statutory provisions under the labor laws determine the terms and conditions of employment of workers. The agreement of collective bargaining cannot override the statutory provisions about such terms and conditions of employment which have been provided under the statutes enacted and enforced by the state. State enact various labor legislations for the welfare of the workers and regulate the industrial relations between employer and his workers with an aim to achieve social, economic and social justice to all. The terms and conditions agreed upon under a mutually acceptable agreement reached between the employer and his workers due to collective bargaining cannot take effect if they are in conflict with the statutory provision which have been made under various labor laws as they are legally enforceable. Now, essentials of effective collective bargaining, that is prerequisites of a successful collective bargaining. So they are strong bargaining agent. The first one is strong bargaining agent. The second one, responsible management. The third one, mutual faith and trust between management and trade union. The fourth one, mutual recognition of their rights and responsibilities. The fifth one, reliance on the fact rather than emotion. And the sixth one, faithful interpretation. The seventh one is honoring agreements. So, with the first prerequisite or essentials, that is strong bargaining agent. The success of collective bargaining depends on the strongly united stable trade union. The first essential prerequisite condition is that there must be a registered or recognized trade union as strong bargaining agent. On a strongly united trade union can act as effective partner in the process of collecting bargaining as the strength of their unity enables to workers to negotiate with their wealthy and powerful employer with more confidence. The second essential or prerequisite for collective bargaining is responsible management. The employer is represented at the collective bargaining table by certain management officials who are charged with successful operation of various aspects of the employee's business. The management officials for the effective collective bargaining have to recognize the fact that the workers are the partners in the industry and play an equally important role for the development of the industry, and also to realize that the investment made for the welfare of the workers goes to increase the productivity of the workers, as a satisfied worker develops a sense of belongingness to the firm for which he works and gives better output due to increase in efficiency. So even if the if the management is investing on the welfare of the worker, the end result or the ultimate benefit is for the industry itself, because increase in worker efficiency will result in increase in efficient production or the management of the industry. Now, the third prerequisite or essential is mutual faith and trust between management and trade union. Mutual faith and trust between the worker and the employer is an essential of effective bargaining. A successful negotiation depends on the attitude prevailing on both sides of the bargaining table. Mutual faith and trust depends on the mental state of both the parties. They sound not to try to take advantage of the other with an attitude to resolve the clash of their interest and find out the ways of adjusting their conflicting interests by identifying the areas of their common interest. Now, to make collective bargaining effective, neither of the parties should bluff. Good faith, open-mindedness, mutual understanding, trust and confidence, and goodwill are the indispensable ingredients of all harmonious relationship. Both the parties must show their commitment and determination to resolve the conflict. Neither party should adhere rigid attitude. They must show flexibility. Now, the fourth essential or prerequisite for collective bargaining. Effective collective bargaining is mutual recognition of their rights and responsibilities. The employees must recognize the rights of the employees, vice right to right to live, right to health, and right to leisure, etc. In the same way, the employees must recognize the right and interest of the employers, that is, profitability, feasibility, etc. Generally, the employees have the interest in productivity, economy of operation, quality, discipline, morality of employers, etc. When both the parties recognize the opposite party's rights, then the amicable relationship exists in between them and the result is a successful settlement. Now, the fifth essential or prerequisite of effective uh, collective bargaining is that reliance reliance on fact rather than emotion. When both the parties rely upon the fact and facts only, the collective bargaining will be fruitful. That is, they must approach with each other on constructive approach rather than unfair practices. They should not be emotional and rigid. The dialogue must be conducted in a peaceful and calm atmosphere. Now, the sixth prerequisite or essential is that there must be faithful interpretation. There must be a faithful, amicable, and goodwill interpretation of the terms of the agreement. Generally, each party interprets the terms according to its own benefit, which again leads for dispute and causes failure of the agreement. Both the parties should understand the provisions with good spirit. And the last and the seventh one, which is an essential or a prerequisite for effective collective bargaining, is honoring the agreement, and this is the most important one. Generally, a successful collective bargain depends on the implementation of the agreement. A successful collective bargaining is reduced into writing. It must be honored by both the parties. It must be implemented with fair mind and good spirit. Now, we also have to consider the scope of collective bargaining. So, with respect to scope of collective bargaining, we have subject matter of collective bargaining, then the bargaining power, then the bargaining process, the structure of collective bargaining, then the collective bargaining in India. So these must be understood to understand the scope of collective bargaining. Now, when we discuss about the significance or advantages or the importance of collective bargaining, we can give 8 points in general. The first one, collective bargaining between labor and management achieves harmonious labor management relationship. Now, the second one, it has stabilizing effect on society. The third, a solution of conflict between labor and management at the collective bargaining table leads to industrial peace, which is key to the industrial growth of any nation. The fourth one, in collective bargaining, the employer involves workers in the process of settling the terms and conditions of employment and creates a democratic setup in his establishment in which a worker also have a say through his representative in the settlement of terms and conditions of his employment. The fifth one, collective bargaining has merits in that it avoids unnecessary litigation and does not involve bitterness between the parties, unnecessary expenditure, unlike the case of adjudication. Now, the sixth advantage is that the process of collective bargaining is elastic, dynamic, flexible, mutually cooperative. It creates peace and prosperity in the industry by narrowing the conflicts between the employer and employees. The seventh advantage is it creates social justice and social change. And the eighth advantage, that is collective bargaining, is quick and it is efficient. So these are the most important 8 advantages that we have with respect to collective bargaining in general. Now, we also have some disadvantages, and they are: the first one, due to collective bargaining, wages are increased and the result is highest cost of production. Producers enhance prices and ultimately the consumers are the victims of many collective bargaining agreements. Now, the second disadvantage is, another drawback is that by and large the settlements are reached by the influence of power politics than by the application of any rational principle. And the third disadvantage is that another weakness of collective bargaining, a weak party has to yield to the economically strong party. Workers are generally the losers. And the fourth advantage that we discuss is another disadvantage is that if the collective bargaining fails, strikes or lockouts will be immediate consequence. So these are the four disadvantages we can see with collective bargaining. Now, reasons for failure of collective bargaining agreement. That can be illiteracy and poverty of workers, or political interference by outsiders, or the inter-union rivalry due to multiplicity of trade unions in India, etc. So we already discussed in a previous session why regarding trade movements in India. We discussed the weakness, that is towards the end of that session we discussed about the weakness, and we discussed about 7 points there. So here we are discussing the reasons for failure of collective bargaining agreement in respect of India. So with respect of India, the main three factors is the first one, illiteracy and poverty of workers, the second, political interference by outsiders, and the third will be inter-union rivalry due to multiplicity of trade unions in India. Now, what is the difference between collective bargaining and a compulsory adjudication system? So, adjudication is the process of trying and determining a case judicially. It is an application of the law to the facts and an authoritative declaration of the result. In it, a case is heard, tried, and determined in a court and is settled by judicial decree. So, let's see to the distinction between collective bargaining and compulsory adjudication. Collective bargaining, the parties settle the matter between themselves, whereas in compulsory adjudication, the judge appointed by the state power deals with the dispute. In collective bargaining, the result of negotiation is an agreement agreed by both the parties, whereas in compulsory adjudication system, judges give the judgment to be followed by the parties. In collective bargaining, results in accommodative resolution by give and take policy, whereas in adjudication it is results in winner and loser. In collective bargaining, there is much of compromise, whereas in adjudication it is no or little compromise. In collective bargaining, we have party to party communication, whereas in adjudication, lawyer to judge communication is what takes place. Now, in collective bargaining, broadened relevance to include focus on interest, values, goals, aspirations, as well as relationships are applied. Whereas in adjudication, it narrows the relevance, essentially limited to issues presented and argued by lawyers. Collective bargaining takes less time, whereas adjudication takes a long time or much time. Now, collective bargaining is less costly and is most convenient, whereas adjudication is very costly and highly inconvenient. Now, collective bargaining, the venue can be fixed at any place that is convenient for the parties, whereas in adjudication, the venue is always the court premises. Now, with respect to collective bargaining, the focus is on relationship. It focuses to maintain a good relationship between the parties to the collective bargaining, that is the employer and employees. They maintain a relationship, whereas with respect to adjudication, it focuses only on the facts and not the relationship. So that is with this session of collective bargaining. Thank you for listening. Click the like, comment and subscribe button. Click the bell icon so that you get a notification when I upload my next podcast or the video. So have a nice day. Take care.